advice would you tell litigants that are going through the family court system? What would you tell them?
That was a quick jump, but I appreciate it because that's the most important thing that I want to say tonight, which is I would encourage everybody to sue a state judge immediately in federal court. The second you feel your rights are violated, if something happens where you don't get notice and opportunity to be heard, if you're not allowed to cross-examine, if they're not following rules, sue them immediately in federal court. You cannot get money. They have judicial immunity. Don't even try it. However, you can, and I want to read this real quick to you. Private parties who corruptly conspire with the state judge, you can sue them under civil rights statutes. Mm-hmm. So I brought this for you because this is a very important point. I have a word processing document where as I read cases, I take the important holdings and I put them under headings so I don't have to go find them again.
Oh, that's great.
All right. So here, let me quote this from this case.
It's only worthwhile to sue them in federal court because you can't really do anything in state.
Yeah, in state court,
right?
You have discretionary writs and stuff like that. Like, why are you going to give them discretion? Why are you going to give the Supreme Court discretion, right? Just go straight to federal court. And then now you're pitting the two systems against each other, right? Mm-hmm. So here, this is very important. Private parties who corruptly conspire with a judge performing judicial acts violative of constitutional rights are acting under color of state law. Mm. So that's important. I wanted to read it again because if you're acting under color of state law, you can be sued under the civil rights statute. So private parties who corruptly conspire with a judge performing judicial acts violative of constitutional rights are acting under color of state law. That's Dennis v. Sparks, and that's a U.S. Supreme Court case, 1980, and the citation is 449 U.S. 24. So you can go after people who are ganging up on you in the family court.
But there's one little small caveat to that because some of them don't know how to do that, and they're trying to get a lawyer, and a lot of lawyers don't want to take that case. They don't want to go after a sit-in judge.
Yeah,
how did they overcome that?
Okay, that's a great question. And so I wanted to mention the thing about private parties, but as long as your statute of limitations hasn't run out, like you don't have to rush into things. The most important thing to do is...
And what's the statute of limitations so people would know?
2 years in Nevada. So from
when?
From the date of the incident. Now there's the continuing wrong doctrine.
The day of the incident? The day the incident happened or from the day you filed?
From the day that the incident, the rights violation occurred, right? But there's all kinds of doctrines. There's always a way around stuff, right? So there's like the continuing wrong doctrine, there's conspiracy, there's all these other things. I understand because I was this person once. I was overwhelmed by the corruption. I didn't know the rules. What do you do? So let me just say this as the chief top priority for tonight. The civil rights statute is 42 USC 1983. If you read that statute, it tells you exactly how to sue a judge, a state judge.
Say that one more time.
42 USC 1983, United States Code 1983. Now what it says is you can get a declaratory order against a state judge. You cannot go straight to an injunction. You have to do declaratory order first, as long as it's available. And if the state judge violates the declaration, then you can get an injunction from the federal judge. Okay. So what that means is you go to the federal judge and you say, this state judge is violating my due process rights and my 14th Amendment liberty interest in my children. I want it to stop. I want you to declare that when they did that thing without notice and opportunity to be heard, that was a violation of my rights. I want you to declare that. Right? Now, how do you do it if you're overwhelmed and you don't know what you're doing? Our court, our District of Nevada, United States District of Nevada, actually makes it very easy. Most of them do. It has a pro se handbook on the website. There's
what website?
On the United States District of Nevada website, there's a pro se handbook. Just read it. It'll tell you what to do, right? There's a form you fill out to file the lawsuit. So you do not even have to draft something fancy, right?
So you can do all this pro se.
I think anybody can do it. And you just
win.
What's that?
And win.
Well, it remains to be seen. But so far, I took prosecutorial immunity. I took qualified immunity. Now, how do you define winning? I don't know because, some things are going well and some things are not going well in the federal court, right? And part of my mission is to lure them in for exposure on certain issues, right? So I'm not in a hurry to get through my litigation with the exception of getting back to my kids. And unfortunately, that's where they made the biggest mistake in the federal court, right? So that's why I would tell people, like, don't wait, like sue right away in federal court. Worst case, like they'll abstain, they'll say, like you need another violation or let's give it more time. But get the ball rolling because if you wait, you're going to get blocked out of federal court on several doctrines, like abstention doctrines or Rooker-Feldman or whatever. And you don't want to do that. And these judges, I mean, I don't know if they're good people or bad people in the federal court. One of the things that I love about federal court, I've never stepped foot in there. Everything is remote. There's no hearings. Like, it's all by the papers.
Oh, wow.
So it's fabulous, right? Like they can't torture me. I just sit in front of my computer and I just write my response, right? And I don't have to sit there and
argue
with some dumb lawyer, right?